everyone. This meeting of the New York Advisory Committee to the U.S. Commission on Civil Rights shall come to order. Today is Friday, July 16th at 1 p.m. I am Brian Hamill, the chair of the Advisory Committee, and also currently present on this call committee members Athena Mutua, Iris Chen, Jamil Dakwa, Donald Durham, Tiffany Graham, Matt Kolodny, Robert Klump, Raphael Mungwal, and Craig Trainer. I expect others will also join. Also present are commission staff, and there may be members of the public who have joined in a listen-only capacity until invited to speak during the public comment at 2:40 p.m. The U.S. Commission on Civil Rights is an independent bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the laws because of race, color, religion, sex, agency, age, disability, or national origin, or in the administration of justice. In each of the 50 states and the District of Columbia, an advisory committee of the Commission has been established, and they are made up of responsible persons who serve without compensation to advise the Commission on relevant information regarding their respective states. Today, our purpose is to hear testimony regarding racial discrimination in eviction policies and enforcement in New York. If speakers begin to veer away from the civil rights questions at hand to discuss possibly important but unrelated topics, I will interrupt and ask them to refrain from doing so. Based on the information collected through testimony, our committee will draft a report that will include findings and recommendations that will be shared with the U.S. Commission on Civil Rights. The Commission will then forward those recommendations to the appropriate federal and state entities. At the outset, I want to remind everyone that this meeting is being recorded and will be transcribed for the public record. I also wish to remind everyone that today's meeting is part of a series of meetings the committee has been hosting on this topic, and all the meeting information is available in the Federal Register. I also want to present the ground rules for today's meeting. This is a public meeting. It's open to the media. It's open to the general public. We have a very full schedule of people who will be making presentations within the limited time available to do so. The time allotted for each presentation must be strictly adhered to. This will include a presentation by each panelist of approximately 10 minutes. Thereafter, the committee members will engage the panelists in questions and answers. To accommodate persons who are not on the agenda but wish to make statements, we have scheduled a public comment session today from 2:40 to
Sorry, Brian, can you hear us okay? One moment, I believe Brian is getting dialed back in. Brian, can you unmute yourself?
Can you hear me now?
Yes, you sound great.
Okay, I apologize for that. To accommodate persons who are not on the agenda but wish to make statements, we've scheduled a public comment session today from 2:40 to 2:55. At the appropriate time, when indicated to do so, anyone wishing to make a statement should press *3 on their phone or use the raise hand function on their web browser to request that their line be unmuted. In addition, written statements may be submitted by email to the U.S. Commission on Civil Rights at mtrachtenberg@usccr.com until August 15th. Please also know that we have interpreters who are providing interpretation in Mandarin and Spanish. Therefore, I would like everyone to speak slowly and clearly so our interpreters can accurately capture the remarks for anyone listening on our language accents lines. Though some of the statements made today may be controversial, we want to ensure that all invited guests do not defame or degrade any person or organization. And as the chair, I reserve the right to cut short any statements that do so. In order to ensure that all aspects of the issues are represented, knowledgeable persons with a wide variety of experience and viewpoints have been invited to share information with us today. Any person or organization that feels defamed or degraded by statements made in these proceedings may provide a public response during the open comment period. Alternatively, you may file written statements for inclusion in the proceedings. Therefore, I urge all persons making presentations to be judicious in their statements. The advisory committee appreciates the willingness of all participants to share their views and their experiences with this committee today. Finally, the rules for the committee Q&A portion of the panel discussions. This Q&A is reserved for committee members only. The committee members may ask questions of the entire panel or individual members of the panel after all the panelists have had an opportunity to provide their statements. Committee members must be recognized by the chair before asking any questions. And in addition, because we have such a large number of members and panelists in a very short period of time, each committee member will be limited to one question, and I ask that you limit it to one part. Some of the questions, previous briefings have had 2 and 3 parts. And I want to ensure that all members who wish to ask questions have an opportunity to do so. So at this time, we are going to begin the presentations. I want to thank all the panelists so much for being here with us today. I very much appreciate the fact that when we had to reschedule our June 18th briefing, you made yourself available to testify and present to us today. So thank you very much for your flexibility. The first invited speaker is Fred Freberg, so I call on you at this time, Fred. Fred, can you unmute yourself?
Hello, can you hear me now?
I can. Thank you so much.
Thank you. Good afternoon, Chair Hamill and distinguished members of the advisory committee. Thank you very much for the opportunity to make a presentation today. My name is Fred Freiberg. I'm the executive director and co-founder of the Fair Housing Justice Center. We're the only regional civil rights organization that operates a full-service fair housing program based in New York City. Our mission is to eliminate housing discrimination, promote policies and programs that foster open, accessible, and inclusive communities, and strengthen enforcement of fair housing laws. Having opened our doors in 2005, we serve a populated region that includes all of New York City and 7 surrounding New York counties, including Dutchess, Nassau, Orange, Putnam, Rockland, Suffolk, and Westchester. Our service area contains roughly 65% of the New York State's population and nearly 4% of the nation's population. The FHJC has one of the strongest fair housing testing capabilities of any private fair housing organization in the nation. We employ on a part-time as-needed basis about 180 testers, mostly professional actors, who participate in undercover testing investigations into housing discrimination. Over the past decade, FHJC testing investigations have led to the filing of more than 120 successful legal challenges that have opened more than 70,000 units of housing to previously excluded populations on all protected characteristics, and resulted in a total monetary recovery of nearly $50 million in damages and penalties. Although this is a relatively small slice of the New York City region's housing market, we have started to change the way many housing providers, government agencies, and others do business and obtain greater compliance with fair housing laws. Personally, my work in combating housing discrimination it spans 45 years. I was a founder and first executive director of the Metropolitan Milwaukee Fair Housing Council. I directed a national testing program for the Civil Rights Division of the Department of Justice that I helped to establish in 1992. I was the field director for 2 national testing studies sponsored by the U.S. Department of Housing and Urban Development. More recently, I was a consultant to Newsday on its 3-year investigation into racial discrimination in real estate sales practices on Long Island. I've supervised more than 12,000 tests in over 20 states, personally participated in over 1,500 tests, and I've been named as a witness in more than fair housing cases. This committee has raised urgent, vital, and relevant questions about racial discrimination in residential eviction policies and enforcement. I'm not the best person to address many of these questions, as FHJC is not an organization that routinely works with clients facing eviction in housing court. So I will defer to other panelists for their expertise in this area. I will instead focus my brief testimony on initially offering some context and providing concrete examples of how systemic and institutional racism remains a persistent and pervasive force in determining where tenants can live and how tenants are treated by race in the New York City region. First, it's important to recognize that the stark patterns of residential racial segregation in our metropolitan region were created by intentional and coordinated actions of the housing industry, government, and other institutions over many, many decades. The policies, programs, and practices of these institutions were driven by an explicitly racist ideology. The aim was foremost to segregate populations by race, protect the social and economic interests and advantages of white people, and tightly control the resources and housing opportunities that were available to African American people and people of color. These discriminatory actions unfairly benefited white people over generations, while systematically isolating and harming others. Today, despite the diversity of populations that reside in the New York City region, it remains one of the most racially segregated areas in the United States. Second, notwithstanding the passage of the Federal Fair Housing Act in 1968, our nation has never fully implemented or vigorously enforced the civil rights law. While this has a lot to do with the paucity of resources devoted to fair housing enforcement over the past 5 decades, it can also be explained in part by the largely complaint-responsive approach to enforcement that is pursued by most government enforcement agencies. For reasons that are obvious to me and anyone who's worked in this field, the burden for enforcing fair housing laws should not fall solely on the victims of housing discrimination. We know from testing investigations that the nature of housing discrimination has changed over time. At the time fair housing laws were enacted, discrimination was quite overt. African American home seekers were frequently met with slammed doors and racial epithets. Today, that image of a housing discrimination as a slam door has been replaced to a large extent with a revolving door, where people are politely and courteously escorted in, out of, and away from the desired housing. It all happens in such a subtle manner that the renter is often unaware that illegal discrimination has even occurred. Violators have learned to conceal their illegal conduct. It is precisely the invisibility of contemporary racial discrimination in housing that ensures its sustainability. This is true in tenant selection practices, land use and zoning policies, the operation of government housing programs, and yes, even in evictions. Residential segregation is reinforced and sustained by continuing racial discrimination, which has a profound and often perilous, lasting intergenerational consequence for excluded populations and subsequently divided and marginalized communities. The enforcement of fair housing laws, in my view, needs to be more proactive, with testing as a centerpiece of any future enforcement strategy. To provide evidence of the persistent and systemic nature of racial discrimination in rental housing, I have attached to my testimony 36 examples of recent investigations conducted by the FHJC that led to the filing of lawsuits to challenge racially discriminatory housing policies and practices in the region. I will not take time now to review these examples with the committee, but what I wanted the committee to understand about these cases is that they illustrate how landlords, rental management companies, real estate companies, and government entities are systematically limiting the housing choices available to renters based on race, often restricting access to entire buildings and communities. Simply put, white renters currently have many more housing opportunities available to them than their African American or Latinx counterparts. While many of these discriminatory practices can be documented through testing, terminations of tenancy, non-renewals, and evictions based on race, with some notable exceptions, present greater challenges. If large numbers of African American tenants and tenants of color disproportionately face evictions and are forced to move, it is important to understand how our dual and discriminatory housing market severely restricts the alternative housing choices available to these tenant populations searching for housing. In our work, we also find that racial discrimination in housing intersects with other forms of discrimination to disproportionately impact Black and Brown populations. Source of income discrimination has been illegal since 2008 in New York City and 2019 in New York State. Despite these prohibitions, and because enforcement has been so lax, tenants with rental subsidies, predominantly African American and Latinx households, face widespread discrimination in the regional housing market. For example, New York City's HIV/AIDS Services Administration, HACA, provides a rental subsidy to people living with HIV and AIDS. A majority of the HACA subsidized population consists of African American and Latinx individuals. FHJC investigations and enforcement work have repeatedly demonstrated how few housing choices are available to HACA subsidized households due to illegal discrimination. Currently, FHJC is working with tenants with rental subsidies to locate housing in areas with higher performing schools, lower crime rates, and fewer subsidized households. The presence of pervasive discrimination based on source of income continues to impede our efforts. As policymakers discuss providing more rental subsidies to households who are at serious risk of eviction, it is essential that consideration be given to substantially expanding resources available for fair housing enforcement to open more housing opportunities to these tenant populations. Otherwise, these tenants may be at serious risk of becoming homeless or ending up renting from one of the many predatory and unscrupulous landlords who have numerous rental holdings and seem to operate with impunity in lower income communities of color. Finally, residential segregation in the New York City region and in many parts of the state creates a vicious self-sustaining cycle that continues to inflict serious harm on people and communities of color by locking African American people and other populations out of opportunities. Racial discrimination in housing not only presents a formidable barrier to renting an apartment or buying a home, it can also limit access to high-performing schools, employment opportunities, healthcare, parks and recreational resources, safe neighborhoods, and even healthy foods. Simply put, where one lives matters. I recognize that dismantling the architecture of segregation in our metropolitan regions and eradicating all racial discrimination in housing goes well beyond the scope of this committee's inquiry.
I just want to interrupt you for one moment to let you know you've got that. You can try to wrap it up where you're finishing your 10 minutes.
One more sentence is all. Thank you.
Yes.
Yet it is hard to envision a substantial reduction in evictions that disproportionately and adversely impact African American and Latinx populations, so long as our government lacks the political will and fails to provide the resources needed to break this cycle of inequality, to vigorously enforce fair housing laws, and to reduce residential racial segregation. Thank you very much.
And thank you so much. So our next panelist, I'll call on Leah Goodrich, please.
Hi, good afternoon, and thank you so much for inviting me. Good afternoon to Honorable Hamill and distinguished members of the committee. I'm very happy to be here and to talk a bit about my work and also really what goes on in housing nationally and specifically in New York City. So as was mentioned, I'm managing attorney for housing policy at an organization called Mobilization for Justice. And I have been in the field as a tenant attorney for about a decade. And in that decade, what I have seen and experienced are the multiple gains, wins, as well as losses in the tenant movement, including recently was the eviction moratorium, but also even before that, specific to New York, the Universal Access to Counsel law. And due to that law, which provides universal access to counsel, I actually am pre-pandemic was in court practically every week, multiple times a week on cases, really getting to see what goes on the ground and what are the legal issues that affect tenants in New York, specific to racial justice. So I'm going to talk about a topic. I named the topic aptly Black Women as Nuisances in Housing. I actually have a forthcoming law review on the topic, so I thought that it would be a good name for this topic, since that will be what I will be discussing. So, thank you. So Black woman is the face of America's eviction and homelessness crisis. I think one of the things that we have seen, particularly in the last year and a half in the midst of the pandemic, is housing always was a major topic, but specifically in the pandemic, we have seen the topic of eviction and homelessness crisis come up. And even more so than that, what we have seen on the national scale is who is the face of this eviction and homelessness crisis. And between 2017 and 2019, tenants living in majority Black zip codes were more than 3 times as likely to be evicted as tenants living in majority white zip codes, and that's in New York. And there are a wealth of other national data really just pertaining to the disproportionate nature of eviction and how it impacts the Black community and Black tenants. But specific to that, Black women are very vulnerable to eviction. And I'm going to talk a little bit about how, as a manifestation of this, Black women have been positioned as nuisances rather than as people that we would help and give public benefits to and empathy to, and so forth. So what is a nuisance? So a nuisance, as I think we all know to some extent, a nuisance can be a person or a thing that either cause depreciation of property or causes one to enjoy one's property less, or it's just an annoyance to some extent, but that touches on the property. And so in the context, what I found was interesting was that, and this is the next slide, was that in the context historically of in the US, we know a lot about loitering laws. We know a lot about different types of laws from the antebellum era. But what's lesser known is that there actually were a subset of laws that were called the Free Negro Nuisance laws. And so I'm going to spend a little bit of time talking about the history, because that very, very much impacts how we view Black women tenants today. And so, so the Free Negro Nuisance laws were basically a set of laws that made it difficult for a slave owner to emancipate his or her slave. So there were many slave owners who wanted to emancipate his or her slaves either while they were alive or at their death. And so there were these laws that multiple states had that said basically, for the good of the state interests, that you cannot emancipate your slaves because they would become a burden to the US. They would be a burden to the state. And the reasons were they would become a public burden. They, for example, some cases wrote and reasoned that because slaves would not be able to read or write or be able to fend for themselves, that they would be a burden on the public. Some said that they would be a moral nuisance because, again, nothing to do with a burden on the public per se, but because of their so-called lack of good character. And then the other part was physical threat. Some cases likened, for example, if some slaves were to see free Blacks walking about, that would cause some type of rebellion. So it was physically threatening. And then depreciation of property. The concept that having what was deemed property now to be free was not, that was a complete depreciation of what could be profitable. So this is just a quote, and I won't read the entire thing, but I'll say, by the act of emancipation, the reciprocal obligations and duties between master and slave, by which the slave owes obedience and fidelity to the master, and the master owes the slave support and protection, are ended. And when this takes place, no one is interested in the protection of the Negro. And so I'll move on to the next slide. But one of the things, and I want us to keep that in mind, one of the main things that we have seen throughout the antebellum era, the Jim Crow era, even today, is this focus on regulating specifically Black tenants and tenants of color, but specifically Black tenants. And a lot of it is under the assumption or the guise of there is either a cycle of poverty, generational poverty, but within that deeper is a sentiment that without regulation, that they wouldn't be able to thrive in society. And so I have this article here. One of the ways that we see this manifest is, and I'm going to talk a bit about intersectionality, Black women and parental status. So for example, in terms of housing, one of the ways that Black women face discrimination is looking at parental status, whether she has children or not, and how her and her family may impact the property and other neighbors. So one, one lesser known fact that a lot of people may not be aware of is that there were a slew of laws that actually prevented single mothers from renting apartments and also from keeping apartments. So for example, it wasn't just in private housing, but it was specific to public housing. And here's pertaining to New York. In 1965, this is a New York Times article, a director of the New York City's Bureau of Child Health sounded the alarm in a New York Times article by alleging that NYCHA barred admission to unmarried mothers, though there was no written policy of this practice. The Housing Authority denied that it summarily rejected unmarried mothers. However, it conceded that the application process was different. A spokesperson told the newspaper that when it became apparent that an applicant was an unwed mother, she was referred to the authority's social consultation unit. I want to go to the next slide. That was in 1965, and I think it's important to note for the background of this that this was also around the time when there had been a report released by, at that point, the Moynihan Report in 1965, which really placed a lot of blame for all of the foibles and troubles of the Black community on the single Black mother. And so I want to talk a bit about empathy versus nuisance. So from the 1940s to the 1970s, psychologists and social scientists published studies which furthered the notion that, for example, white unmarried mothers were mentally ill and they were deemed innocent, and because of that merited social empathy. Thus, much like the impotent category of the English Poor Laws, which described people who were unable to work due to physical or mental impairment, the purported mental illness of white single mothers sheltered them from blame entirely. Black single mothers, however, were seen as unworthy for help because they were framed as responsible for their own plight. So what does that mean in a nutshell? That means that, for example, from decades ago, if a single mother was looking for housing and she was white, being a single mother was not seen as positive entirely for anyone. But specific to race, this predicament, if you will, she was deemed innocent. She was deemed as someone who needed help throughout her situation. But for a Black single mother, what was primarily looked at was how would her and her children behave on the property? What kind of nuisance would they bring? How loud would they be? How many other kids and children would she have? So it is important for us to think about the differences in how we view empathy and nuisance as it pertains to race. And we cannot divorce that when it comes to tenants and specific to Black women tenants. So the next slide. These are cases that I've laid out. This is
Leah,
what I refer to as illegal construction of Black
moment.
women as nuisances in housing. This is a Jim Crow era. These are all cases, in fact, that the NAACP Legal Defense Fund commenced against housing authorities because they had a practice of denying housing to Black single mothers on the basis of their race and their gender. So, for example, in one of the cases in Thomas v. Little Rock, this was in Arkansas, there was a housing authority. And as we know, a lot of housing authorities have multiple buildings. And this housing authority, I believe, had two buildings, and it was segregated. One part was only for Black tenants, and the other part was only for white tenants. And they only applied the policy of not being allowed to be a single mother to the buildings that house Black tenants. So again, there we see this sort of hyper-regulation of
Leah,
Black women tenants from decades ago
Leah,
that I'm going to talk in a bit about how we see it today.
Okay, Leah, can you hear me? Your
Yes.
10 minutes are up, and we've only got 30 minutes left for the other 3 speakers. So I'm sorry, I really need you to wrap it up in about 30 seconds. Okay. And you can obviously submit any additional information to us, which I appreciate, but I want to make sure the other speakers have their full 10 minutes. Thank you.
Okay, will do. Next slide. So in sum, we see Black women and gendered violence today. We see that in sexual harassment. We see it in domestic violence. In fact, there actually have been domestic violence cases where Black women have literally been deemed a nuisance because they're calling the police. Next slide. And though we have some laws that protect them, they do not always protect them. I can speak more about that. I've had cases where this has happened, but I can't go into detail now. Next slide.
Leah, listen, we can't, this is such an important topic, but I've only allotted 10 minutes and I don't want to take away the time from the other speakers. I do apologize.
No worries. Sorry, I didn't realize 10 minutes had passed. Thank you so much for the opportunity to testify. And if anyone has any questions, I'm more than happy to answer afterwards.
Yeah, please stand by. We're certainly going to have questions. Okay, Laura Phelps, you're the next panelist. Thank you. Thank you, Leah.
Thank you. Thank you all for having me on the panel today. My name is Laura Phelps. Please feel free to read my bio on the current PowerPoint slide. From experience, I've seen that persistent racial discrimination in eviction policies and enforcement in Albany, in the city of Albany, New York, has civil rights implications. In Albany, half of renter households of color were unable to afford the cost of their rent before the pandemic hit. Renters are far more likely than homeowners to be low income, to be people of color, to have a disability, and to be women. I submitted a memo to this committee that outlines housing instability in Albany, explores the degree to which that precariousness is racialized, and also offers a long list of local, state, and federal policy solutions. For my testimony today, I wanted to share one anonymized tenant story. This story sadly is not unique and is representative of struggles faced by the thousands of tenants I've worked with over the years. And after the story, I'll highlight just a few policy solutions. I worked with a tenant who I'll call Mr. K over a few years. He lived in a predominantly Black, historically redlined neighborhood in Albany, where most of the housing is substandard rentals in vacant, blighted buildings. He rented an old single-family house for more than 13 years and had a month-to-month lease with a lease that was previously expired, so he was a month-to-month tenant. He is disabled and has full custody of his severely disabled granddaughter, for whom he's a full-time caregiver, and shared custody of his 3-year-old granddaughter. He paid his rent of $1,100 with disability income and a Section 8 subsidy. Whenever maintenance was needed, his landlord would not address repairs. Mr. K knew that a failed Section 8 inspection paired with his landlord's outright refusal to make repairs would result in a forced move for his family. For years, Mr. K made necessary repairs to the home himself and paid for them out of pocket. This housing was valuable to him. The quiet and predictable single-family house helped alleviate symptoms of his daughter's disability. Mr. K was unable to find another single-family rental in Albany where the landlord would accept his Section 8. Whenever I saw him, he was always searching for another place. Mr. K's landlord would also harass him and make unwanted comments and gestures that were sexual. The landlord left a sex tape in Mr. K's mailbox and more than once actually exposed himself to Mr. K when he came to collect the rent. Mr. K asked if he could mail the rent instead, but the landlord stated that he wouldn't accept his payments unless they were cash in hand. In 2017, Mr. K began to receive bank notices stating that the house was being foreclosed. Despite his timely rent payments for over a decade that were subsidized by Section 8 payments directly to the landlord was not paying the mortgage. Between the harassment, repair issues, and foreclosure notices, Mr. K began holding back his rent and searched even more urgently for new housing to no avail. After 2 months passed, Mr. K was sued for non-payment of rent at an amount twice what he actually owed, plus a number of fees, including an attorney fee for the landlord's representation, a processing fee, a filing fee for the petition, and late fees. With no right to counsel, Mr. K tried calling the Free Legal Service Agency, but no lawyers were available to take his case. As his advocate, I was able to discuss his rights with him, explain legal terms, help him keep looking for new housing, and help him organize his evidence. I would be allowed to stand next to him silently at his hearings, just for support. At the first appearance, Mr. K felt compelled to raise the distressing sexual harassment issues that he had endured and was immediately told that the matter had nothing to do with the eviction proceeding. He further raised the issue of the pending foreclosure and was told that until the day the landlord lost the building, all rent would be due and owing. It didn't matter if he was paying the mortgage or not. Mr. K requested a trial so that he could further dispute the eviction, show his proof of the status of foreclosure, and present receipts of the repairs he'd made over the years to try to deduct those costs from the rent. Just before the trial started, I got back information from the Albany Buildings Department that the landlord had no residential occupancy permit, which in the city of Albany is required for every rental unit. Based on the local law, it was illegal for this landlord to collect rent for this apartment when they didn't have a permit. When Mr. K raised this issue at the very beginning of his trial, he was told that his failure to preserve that legal defense at his first appearance made it impermissible for the judge to consider it at the trial. It did not matter that he was pro se. Had we been able to get this information about the occupancy permit sooner, the case would have been dismissed. Throughout the trial, Mr. K's granddaughter was teething and crying in his arms in a stroller next to us because he could not find childcare that day. Ultimately, an order was made for Mr. K's eviction pending full payment of the months of rent he withheld. The cost of repairs was not deducted because the judge did not find the repairs to be urgent threats to life or safety in his unit. Of course, Mr. K was proactively addressing the disrepair in his apartment to stop any imminent threats to life and safety from materializing where he was taking care of his daughter and granddaughter. About a week later, after he made his first payment in the stipulation to avoid the eviction, the landlord let the house go to foreclosure. The bank gave Mr. K 90 days to leave his apartment, and without good cause eviction protections, Mr. K would be defenseless. After the fruitless search for a single-family house where Mr. K's subsidy would be accepted, he endured an emergency move into a large tower. His daughter's symptoms included seizure attacks and serious mobility issues, which proved much harder to manage in the large housing unit. After moving him, I helped him write a complaint rights, which I'll refer to as DHR, to address the sexual harassment. First, we tried to reach the City of Albany Fair Housing Office per a local ordinance which mandates an office be staffed locally. We were informed that the office is not staffed, could not receive complaints, and we were given no information as to whether the office would be accessible sometime in the future. Probable cause was found by DHR with Mr. K's complaint finally in spring 2019. When DHR interviewed the landlord, he outwardly admitted to exposing himself and to making comments to Mr. K that were sexual in nature without his consent. After Mr. K was assigned an attorney through DHR, I didn't hear from him for about a year. In January of this year, 2021, he reached out to tell me that his case got dismissed for a reason he didn't understand. I was not able to detangle what exactly happened over the year of investigation and litigation, but I successfully referred him to an attorney. In my last follow-up with him, he stated it had yet to be resolved. Eviction is not just a condition of poverty, poor health, and instability. It's most certainly a cause. Positive government action is social opportunities and protection under federal, state, and local laws. I'll close with a short list of federal level policy solutions, many of which could also be implemented at state and local levels. Federally, please repeal the Faircloth Amendment and invest in the construction of truly affordable community and government-controlled housing as a mandatory budget spending item. This isn't low-income housing, tax credit housing, or other tax credits for private developments which are not deeply or permanently affordable. At the state level, stop subsidizing private luxury housing development, which is overwhelmingly exclusive of low-income people of color, and repeal 485A tax incentives entirely. Love to see a reinvestment in existing public housing and making that spending mandatory rather than discretionary. The rental assistance demonstration programs that communities have been subjected to, also known as RAD, are an irresponsible solution to the historic and ongoing fiscal starvation of our nation's affordable housing, and they actually erase what little permanent affordability we have left. Enacting universal rent control. States were first adopted in response to the Great Depression in 1942. Because of affordable housing shortages and the overall national economic crisis from the pandemic, which is felt disproportionately by renters of color, I feel emergency federal rent control should be seriously looked at. establish national good cause eviction protections so that Mr. K doesn't face eviction, or people like Mr. K don't face eviction because their landlord stops paying the mortgage or because they complain about discrimination or request repairs. We've been fighting for a good cause eviction bill in New York State for decades, really ramped up that fight in the past few years, and we've had a disheartening lack of support by our state government. Pass and invest a tenant right to counsel across the country, in New York State and locally, and housing cases so that tenants like Mr. K can have meaningful access to the justice system, a shot at a fair trial, and to uplift values of equal protection in the United States. And lastly, fund local enforcement mechanisms for fair housing protections so that Mr. K could have worked with an accessible officer locally, and funding local code enforcement departments so that Mr. K could have worked with a reliable system to assert his rights. Thank you for considering my testimony today.
And thank you so much for being here with us today and your comments. We really appreciate them. So our next speaker is Senator Brian Kavanagh.
And as a reminder,
yourself?
Yes, thanks, Brian.
So, Senator, it looks like you're still muted. You'll need to unmute yourself.
And you'll want to do that through the mute button at the bottom of your screen. Do you see that okay? Okay, we still can't hear you. Can you try selecting it again?
There, it looks
Hi,
like
can you hear me now?
now.
Yes,
Sorry,
perfect.
Thank you.
I was hitting the button repeatedly and getting a note that said I could not unmute myself, which was true, but I'm not sure why. But anyway, excuse me. Thank you very much. It's wonderful to have the opportunity to speak with you today, and I really thank the committee for focusing on this tremendously important topic, and also really honored to be with a terrific group of panelists, especially Laura and Fred, who I worked very closely with and have provided great insight into hearings that we've had at the Senate Housing Committee. So, but thank you again. So I don't have the expertise that some of your other witnesses, including today's distinguished panel, have. But I hope to offer some useful perspectives on our legislative and policymaking activities that I think are relevant to your discussions. So first, I'd want to talk a little bit about first about activities that are specific to fair housing standards enforcement. And I also want to talk, as Laura alluded to toward the end of her testimony, more general housing policies that I think are really quite relevant to the question of limiting evictions and limiting discrimination with respect to evictions. So first, on fair housing, Fred mentioned already we had the Newsday investigation of a few years ago, which I'm sure you're familiar with, really did spur a lot of activity at the legislative level. The Senate, my colleagues on the Consumer Affairs and Investigations and Government Operations Committee, along with my colleagues on the Housing Committee, convened hearings and investigations. We issued rare legislative subpoenas to people who declined to participate in those investigations, and had several hearings and ultimately issued a report. The focus of that investigation initially was, of course, the sales market, particularly focusing on Long Island, but the recommendations and the legislative package that we concluded were necessary have broad implications for the housing market, including the rental market. So we actually passed a 7-bill package through both houses of the legislature, and it's now awaiting the signature of the governor. It increases fines very substantially for violations of the fair housing laws. It imposes a fee, a significant surcharge on brokers and salespeople in the market. Both of those provisions will raise revenue to then devote that revenue to fair housing testing, which, as Fred Freiberg testified, is really the most critical way that we can enforce our fair housing laws. Similarly, we required additional training, both implicit bias training and training of participants in the housing market in anti-discrimination practices. Again, that is focused in particular on the brokers and salespeople, but I think that to a surprising degree, those participants in the market did not understand their basic obligations under fair housing laws. And it seems likely that other participants that may be even more directly related to the eviction process may also suffer a similar lack of awareness about how implicit decisions that they make really can affect people adversely. On the other related, very relevant topic, I think, has also been mentioned briefly by one of my colleagues on this panel, but it's the source of income discrimination. It has been illegal in New York City since 2008, as has been mentioned, and in February of the past year, we passed a law making that illegal throughout the state. I'm sorry, that actually was in 2019. It was a little blurring of the passage of time with the COVID pause. But we've seen, unfortunately, that it continues to be the case that that is not very well enforced. It's relevant, I think, to your investigation because source of income discrimination is primarily about making sure that generally applicable subsidies for rent are available across the board. And we know that there is a very heavy correlation between low-income communities where these subsidies are needed because of all the historic discrimination, and those communities being members of protected classes. If those subsidy programs don't work, it increases the likelihood that people are going to get evicted, because often subsidies like that are our first line of defense against people getting evicted because they can't pay the rent. And it also exacerbates the general harm of eviction because those programs are also the things that minimize the period of housing stability or homelessness after an eviction. So unfortunately, just to mention the Housing Rights Initiative, who I think may have testified before you, we joined them in announcing the results of an investigation where they systematically called brokers to figure out if they would take Section 8 vouchers, and basically found that in many, many cases they wouldn't. And there is a class action lawsuit that they have filed to try to address that. But again, that is an area that is ripe for additional proactive enforcement by government. The other thing I would note is that you're examining the particular connection between evictions and discrimination, and it's an extremely important topic, and I think something that has not been fully explored from the research I'm aware of. But it's also, I think, important to the extent that you're recommending potential remedies, that you consider some of the more generally applicable protections against evictions and other measures that are intended to protect tenants across the board. If you find that the enormous harm of evictions is disproportionately falling on people from certain communities with protected characteristics, one way would be to diminish the discrimination. Another way to address that would be to simply reduce the extent to which evictions are prevalent in our society, because they're far too prevalent and they have enormous destructive impacts that folks have testified to in other panels. So in New York State, we have some very aggressive tenant protections that unfortunately are not uniformly available. The first is rent regulation, which affects more than 1 million apartments in New York City and in some of the surrounding counties, is really the gold standard of rent protection and tenant protection. People focus on the extent to which it prevents rents going up and keeps communities affordable, which is of course an important aspect of it. But it also basically guarantees a tenant a lease renewal. It is a very strong version of what's sometimes called good cause eviction. You can't evict somebody at the end of their term of their lease unless they are not paying the rent. That's basically the only, and there are some other limited exceptions to that. Unfortunately, over the course of a couple of decades, those laws had gotten a lot weaker, and there were in fact incentives in those laws to displace people. There were many provisions that allowed people to raise the rents rapidly when the units became vacant and to deregulate them. As a result, you had a thriving business in basically acquiring buildings, vacating them, removing all the tenants, and gentrifying rapidly and making a lot of money through that. In 2019, through the Housing Stability and Tenant Protection Act, we basically eliminated all of those loopholes and made those laws much stronger. And as a result of that, the data for this is not complete because we did those laws in June of 2019, and of course COVID 19 really did affect the markets in very dramatic ways beginning into 2020. But in the fall of 2019, we already saw very substantial reductions in evictions across the board in New York City. And we believe that those are a direct result of the HSTPA, the strengthening of those laws. There are provisions in that law that permit other localities for the first time throughout the state to opt into that kind of strong rent protection, but they are limited to places where there is a tight market, where the vacancy rate is below 5%. Many of our upstate communities do not meet that condition, but still are very much in need of rent protection and eviction protection. Laura Feltz mentioned briefly a proposal to create. So one thing you could do is, of course, create strong rent regulation around the state, but a simpler approach would be to create what is called good cause eviction. Under current law, landlords can evict people basically for no reason at all. If their lease is up, if they don't have a lease and they're month-to-month tenants, they can simply ask them to leave. That causes a situation where, of course, there's a great deal of housing instability. It particularly prevents tenants from enforcing their basic rights, even basic rights to standards of habitability. Because if a tenant can push you out, if the landlord can push you out, it's very hard to complain. And we had absolutely harrowing testimony in our series of hearings around the state about tenants who were told after many, many years of living in buildings, upon complaints about conditions in their apartments, they were simply told to leave. And that is unfortunately, although it is illegal to do retaliatory evictions, the situation where landlords can evict for no reason is really ripe for people to take advantage of that situation. We also, interestingly, had many landlords testify directly, both in our code enforcement hearings and in our...
Senator, I do apologize.
Am I getting to my time?
I need you to try to, wrap it up in the next couple of seconds. Thank you.
Okay, I will wrap it up quickly, just to say that many landlords were very express in their notion that if somebody doesn't like conditions, even if they're habitability conditions, they can simply leave. And obviously that's a situation where that's ripe for abuse. Just to mention one other topic for your consideration, code enforcement. In markets where conditions are really terrible, often inhabitability of housing units causes evictions directly because the units are simply become uninhabitable, but also eviction because people try to enforce those rights is a significant problem in many states. We found through a separate investigation that code enforcement is deeply lacking in much of the state. The state has very substantial resources that it ought to be using to strengthen those local protections, but hasn't been using them so far. I will end there. And I'll follow up with additional information on those topics, but thank you.
It's so hard to limit you all because all of this is so important. So at this point, I'm going to call on our final speaker for today, but also this is our final briefing on racial discrimination and evictions. So at this time, Tzeitel Andino-Caballero, if I'm pronouncing your name correctly, with the U.S. Department of Housing and Urban Development. You may unmute yourself and you've got the floor for 10 minutes. Thank you.
Thank you. First of all, I would like to express my gratitude to both the committee as well as the U.S. Commission on Civil Rights for its interest in taking a closer look at racially discriminatory eviction practices in New York, and in furthermore understanding the civil rights framework which prohibits such unfair conduct as well as invidious practices. My name, as you stated, is Tzeitel Andino-Caballero. I am the Deputy Regional Director for Region 2, specifically the Office of Fair Housing and Equal Opportunity. Briefly, I will explain my office's mission. If please, we could move on to the next slide. Oh, the next slide, sorry. Great. So my office is committed to ending housing discrimination throughout the nation. Our day-to-day actions are aimed at eliminating segregation and economic disparities, which have historically existed in neighborhoods throughout the nation, including but not limited to the New York State area. The Office of Fair Housing achieves this through efforts such as investigating and resolving housing discrimination complaints, conducting compliance reviews of recipients of federal funds, as well as educating the public on federal anti-discrimination obligations. Next slide, please. So this is a listing of the primary statutes that my office enforces. In the interest of time and brevity, I will just focus on discussing Title VIII of the Civil Rights Act, which is popularly known and referred to as the Fair Housing Act. Next slide, please. There are 7 protected groups under the Fair Housing Act. Specifically, individuals are protected because of race, color, national origin, religion, sex. The classification of because of sex does include sexual orientation as well as gender identity. Familial status, which is a very interesting category. Somewhat in line with what Leah Goodrich was indicating. Many times familial status discrimination is utilized as a pretext for discriminating based on other prohibited bases, such as race or color, for instance. And then finally, last but not least, we have disability anti-discrimination protections that are included in the Federal Fair Housing Act. Disability does include protections for individuals who have physical as well as mental disabilities. Next slide, please. So generally speaking, the Fair Housing Act prohibits discrimination in the sale, rental, or financing of housing, as well as in other housing-related transactions. Some examples of illegal discrimination can include applying different terms and/or conditions during or after home acquisition, as well as during or after the rental of a home. Denying a housing application or a dwelling, or evicting persons simply because of their protected characteristics, steering to certain communities, or restricting persons to live in certain areas of a building or a complex simply because of their protected characteristics, advertising housing, and expressing preferences for certain persons, or in the alternative, expressing not wanting certain individuals simply because of the class of persons they belong to, are all examples of discrimination. I would like to pause here for 1 second, and similar to what Freiberg was explaining at the beginning of his presentation, I want to point out that discrimination is not always as obvious. It does take many shapes and forms. Many times in our lives, we may have experienced overtly and pointedly discriminatory statements, such as maybe reading a classified ad where it stated that no children are wanted in a certain home that's available for rent. But most times, however, discrimination is not as manifest or as obvious, and it will show itself through more subtle and sometimes even understated and sophisticated ways. And I want to very briefly point out at several examples. For instance, selectively evicting members of a protected class, but not others, even if such eviction would have otherwise been lawful, is discriminatory conduct and illegal under federal fair housing laws. Furthermore, strictly applying fees, charges, penalties to one or more protected groups of persons, while more loosely enforcing such fees, charges, or penalties with others who belong to a predominant group that would be the majority in a particular locality, is another example of a more subtle form of discrimination. In other words, whenever vulnerable groups are overburdened through the abusive application of fees or penalties, that is discrimination under fair housing laws. This inevitably, of course, increases pre-existing vulnerabilities of minority groups while placing them in an even further unequal footing in comparison to other non-protected counterparts. And so basically, these are some examples that illustrate the artificial barriers and discriminatory impediments which may be created with the intentional or sometimes even unintentional goal of restricting housing and limiting inclusivity. Next slide, please. Very briefly, in terms of our complaint process, basically, my office is tasked with investigating complaints alleging some type of fair housing discrimination. And as part of this portion of the presentation, I would like to take a moment to submit to the advisory committee for inclusion in its records, an example of a complaint investigation that was conducted recently by my office. And this particular case was filed against a HUD grantee. Through what we call a letter of findings, my office found racial discrimination was being perpetuated by this grantee. The grantee is located in upstate New York. And specifically, the grantee was administering a mixed public housing and Section 8 voucher program and was enforcing certain criminal records, rules, and policies that it had developed in a manner that was adversely impacting and overwhelmingly affecting racially protected tenant families whose leases were being canceled with subsequent eviction actions being pursued. The end result, of course, was that families were being deprived of HUD-funded affordable housing. After my office issued its findings, we engaged the grantee in settlement negotiations to voluntarily resolve discriminatory deficiencies through what we refer in the HUD world to as a VCA, or Voluntary Compliance Agreement. This agreement was eventually executed and provided both very comprehensive individual reliefs to the complainant person and her family, as well as public interest reliefs aimed at ending the identified discriminatory practices by mandating institutional-wide changes. Corrective actions in the agreement included, for example, monetary compensation to the aggrieved family and modification of housing policies to not only bring them into compliance with fair housing laws, but to also ensure that these satisfied the spirit of fair housing laws, which is none other than achieving integration and inclusivity. Next slide, please. So very briefly, I know we're tight on time, but I would just like to point out that anyone who believes having been discriminated against can reach out to my office and obtain further information on how to file complaints. We do provide various means for filing complaints: online, regular mail, email. I should have included fax. We also have that alternatives, very 1990s, but still we make it available. Just know we pride ourselves in being available to the public through varied means because our sole interest is to serve and protect as many discrimination victims as we possibly can. I have tried to condense what would ordinarily be a 1-hour presentation in 10 minutes. So I'm sorry for glossing over many important subjects, but if at any time any member of the committee or the public were to have any questions, in the next slide, my email is being included, so anyone can please feel free to reach out, send me a message, and I will happily respond. Again, I thank the committee for joining the fight against discrimination by studying racial bias and inequalities in New York. Thank you once again for your time and attention.
Okay, thank you so much, and thank you to all of our panelists. This is the time for question and answers, and we'll go to 2:40. It's a little bit less time than we normally have. We have all the committee members on the line except for one, which that means we have 13. We have less than 40 minutes for Q&A. So I will ask the committee members to please limit the question to one, and also for the panelists that are responding, if you can try to make a brief response. I will ask the panelists to raise your hand in the participant list, and I'm going to call on people according to the hands being raised on the participant list. Matt Kolodny, one member, has informed me he has to leave by 2:15, so I'm going to call on Matt first, and then we'll go through our other order. Matt, you have a question?
Thanks, Brian. Yeah, my question is for Leah or Lee. Sorry, I forgot which pronunciation that is. Since you didn't get to finish your presentation, I'm just curious if you can briefly chat for a minute about any sort of potential solutions to all this. I really appreciate the historical context, but I really am focused on action, and I'd love to hear any thoughts you might have.
So Leah, you may answer the question.
I'm sorry, you said Leah? I just want to make sure.
Yes.
Okay.
Yes, it was directed
right.
just to
So
you.
one of
Thank you.
yes. So there are a couple of specific resolutions that I had. One is to it's not, I think it's fair to say we could use stronger tenant protections, but in addition to that, what I have experienced as an attorney is there is a lot of sometimes personal interpretations of laws from judges, and I think that it's helpful to have judicial training as well. So for example, with the DV issues, I have experienced when going before judges, sometimes, for example, they may think of the case or of the situations through a lens of saying that the tenant may be a nuisance or of some sort. And I don't think that that's intentional. I do think that that's something that with more training would be helpful. So I guess one is no matter how many laws we have, at the end of the day, if the judges are deciding the interpretation of that, then we also have to make sure that their lens is clear as well. The other is, I strongly think that we should consider as a state reparations. I think that this is really important. There's a lot of history in New York City. A lot of people aren't aware that, Central Park before that was called Seneca Village for mostly African-American landowners, and that was, they were forcibly removed to build this. There's a lot of history of housing and displacement of Black New Yorkers in New York that a lot of people don't know about. And because of that, that is in part of why we have a disproportionate impact of the eviction crisis and the homelessness crisis.
Thank you.
So thank you for
so much,
asking.
Athena. Yes, thank you. Athena, do you have a question?
I do, thank you. I'm wondering if the
Yes.
panelists, can you hear me? Um,
Yes.
can tie the relationship a little closer for me. So how does segregation as this kind of self-perpetuating system relate to eviction generally and to the racial ethnic disparities we see in evictions? So I'm wondering if segregation might serve as a partial frame for understanding some of the systemic roots of the eviction disparities. For instance, we see that we have some evidence that high levels of evictions in New York City and I think in Buffalo occur in predominantly segregated areas that house large numbers of Black and brown people. Mr. Freiberg's testimony and written submission makes clear that intentional discrimination against Blacks in particular in securing rental homes is alive and well. When people are evicted, they have to find new homes, and so they then face those barriers. So that seems to me to be a connection. And we also know that a lot of studies have been done on kind of the income wealth gap. And since you have Black and brown people who have had problems, have been discriminated against in terms of housing, which has been the primary way in which people accumulate wealth, we see this gap. So those are some connections that I see, but I wondered if anybody might be able to make those links between segregation as a possible frame and eviction more clear to me.
Okay, and for any panelists who wish to answer, please raise your hand in the participant list. Laura Fell, I see your hand is raised.
I just would want to, I think there's lots of comments that all the panelists could make about this. I would make just one that's the most relevant to my experience, which is historically segregated communities that were then subject to redlining have the worst housing conditions. So particularly in any community that's older, the housing stock is older, and a lot of it was built in periods of segregation that it was intended to be temporary, or it was never intended to be well constructed. And now you see overwhelmingly that still persistently people of color live in that housing. And because we don't have good cause eviction protections and tenants' rights that allow people a right to remain when they're trying to fight for repairs and better housing, you kind of have this intersection between segregation, housing conditions, and eviction.
Okay, thank you. And seeing, I see Brian Kavanaugh, the senator, your hand is raised. You may answer. If you can unmute yourself, Senator Kavanaugh.
There we go. I'm getting the hang of it,
Yes.
I guess. Yeah, I agree with what Laura said, and I would just add that because of patterns of segregation where people fled from central cities, and and of course that phenomenon was exacerbated by all kinds of government policy and all kinds of discriminatory practices in our suburbs and by government at all levels. You end up with many cities that are heavily segregated, either relative to their surrounding areas or within the cities. And unfortunately, a lot of the activity that would improve people's lives and the housing conditions and enforce our laws are left to localities. So you end up with a lot of places with relatively small tax bases, and often the state's answer to housing conditions in there has been, the local code enforcement should enforce the codes, local agencies should be looking for discrimination. We need, so what that leads to is one thing I tried to suggest in my testimony, which was we need more state level resources to go into communities to make sure that enforcement is done at the local level, make sure they have the resources to improve conditions at the local level, because otherwise we're going to continue to see these patterns indefinitely.
Thank you. And I see that Fred Freiberg's hand is raised. Fred?
Yes, I simply wanted to add that I think the advisory committee member makes very good points and in some respects answers her own question, but I do think that there's two issues that I just want to underscore. One is the limitation of housing choices so that populations, Black and brown populations particularly, are confined to certain areas yet. Not only is it consistent with our history, but then it makes those populations, it really puts them at the mercy of some of the most unscrupulous, worst landlords in the city. And that perpetuates this cycle as well. And I think the other thing that segregation does, and we all need to keep this in mind, it's not just about the conditions in communities of color, but affluent communities, white communities around the region do everything they can to exclude those populations from opportunities. So segregation has both an exclusionary aspect to it as well as a discriminatory one in the communities where those populations currently reside. And we have to look at both ends, because communities are building into their zoning codes various restrictions that prevent low-income populations, African Americans, Latinx populations from moving to certain communities. And these are reinforced by patterns of segregation in the metropolitan region.
Okay, thank you so much. We're going to go on to the next question. Iris, do you have a question?
Yes. I, along Matt's lines, really starting to think about actionable recommendations. Several of you have echoed similar solutions, such as cause-based eviction. You've talked about a rather good cause eviction. You've talked about enforcement and testing. And at the same time, you've also talked about solutions that have worked, like right to counsel. So wondering what exactly is needed to make happen the remedies or the solutions such as cause-based eviction. Like what led to the success of right to counsel, for example, that you feel might be transferable to these other potential solutions? I know that Senator Kavanaugh talked about state funding to try to drive some of the local change, but I'm wondering if there's anything else you all can think of.
Okay, does anybody wish to answer that question? If you'll just raise your hand in the participant list. If so, Senator Kavanagh?
I want to give my colleagues an opportunity, but so just as a practical matter, several of those things require changes in law. In New York City, it is really up to the state, because there's a law that says New York City cannot have more restrictive tenant protections than the state laws. In the rest of the state, some of these things could be enacted locally, but it's been challenging, and good cause has now been, as Laura meant, to fight for a number of years with a particular focus in the last, I would say the last 3 or 4 years, there's been a real focus on it. We have had lively conversations about whether we could enact that at the state level. I think one of the things is that we need a further education. I mean, if you take economics 101 at almost any university in America, and the economics professor wants to tell you why free markets should be allowed to participate, when they're looking for a destructive government policy to explain why government shouldn't intervene. They talk about rental markets and they talk about how governments shouldn't be setting prices. They shouldn't be restricting supply and demand. And they're just plain wrong. Like when you are engaging, when you're providing a scarce resource and you have really tremendous difficulties of people accessing that resource, you have discrimination going on, it is an entirely appropriate subject for regulation. But a lot of people view good cause and rent regulation as these like terribly restrictive, destructive things, and we need to change that. We need to. It's about educating policymakers and legislators, and also the general public to how fruitful that kind of approach could be to protect people and just improve living conditions for everybody.
Thank you. Laura Phelps?
Thank you. I think that the single most important thing is organizing, grassroots level organizing, and ensuring that tenants are being brought to the center to be able to engage in narrative shifting and to be able to make arguments. I think what was mentioned was the New York City win for right to counsel. And that was one of the most amazing organizing efforts that you could ever imagine. And they engaged so much in why it was an issue of equal protection, and it's a constitutional issue. And being able to have equal protection under the law is not just an issue of being good to people or kind of a moral issue. It's a constitutional issue, and it's something that our government is obligated to do. And organizing is a really important strategy to be able to win the remedies that we've discussed.
Okay, thank you so much. The next question, Jamil, do you have a question?
Yes, thank you all for your presentations. We heard some suggestions for prevention, for mitigation, for structural changes. I appreciated the recommendation that we heard earlier from Leah on reparations. My question is really, because of the different presentations had covered different aspects of different responsibilities, particularly between federal, state, and local actors, to what extent you can give us, and this is a question for any of the presenters and the witnesses, if you can give us any recommendations of improving the coordination between the different actors, the federal government, the state, through oversight, implementation of what the Senator Kavanaugh shared with us, as well as with the local, but also with the non-governmental sectors around testing. What specifically can be improved in order to make that coordination of enforcement better for the people, so that will be more protection and less people evicted easily from their homes? Thank you.
Okay, so would any of the panelists like to answer that question? So raise your hand on the participant list if so. Okay, Tzeitel?
Yes, I will say in our experience, there's a lot of issues with the lack of knowledge and understanding at the court level in terms of how to apply anti-discrimination laws, especially when there's a conflict between, for instance, federal anti-discrimination laws and maybe other landlord-tenant laws. In theory, as we all know, federal law is supposed to trump local law whenever local law runs contrary and afoul to federal requirements. However, we see many times the courts struggle with adequately applying such principles. And this is very lamentable. Many times we'll learn about a discriminatory eviction having taken place after a judicial decision has been rendered, sometimes even when it's at the appellate level. And so then our role is limited to maybe trying to seek assistance with filing an amicus, or so then we have limited recourse is what I'm trying to say. I would say that would be one of the top impediments to preventing racially discriminatory eviction practices.
Thank you. Fred?
Yes, thank you. Thank you for that question. You know, the coordination issue is a huge one. It's not just about paucity of resources. It's about federal, state, and local governments working together to make a change. And on the enforcement side of things, unfortunately, the common denominator between all three levels of government is largely inaction. It's been passive and uneven over the years, fair housing enforcement. And it has been uncoordinated because we've worked with all levels of government on enforcement. And I can tell you that there's very little interest in working collectively and in a coordinated manner to try and eliminate this scourge of discrimination in the housing market. And that's number one. And number two is the Fair Housing Act, as you probably know, contained a provision that required the federal government and all recipients of federal financial assistance to affirmatively further fair housing. I have to tell you that that provision of the law has never really been fully implemented. And that is precisely where the federal government, state governments, local governments could be working in tandem to try and reverse the harm caused by decades of discrimination and segregation. But it simply has not happened. And I've been involved in this field for 45 years. I can tell you I don't see any period of time in which that kind of effort was undertaken. And HUD is now moving to re-implement the AFFH rule. The state has now passed an AFFH obligation, thanks to Senator Kavanaugh and his colleagues. But getting people to work together and make these things real so that there are tangible results that come out of these efforts, that's what's been lacking. So I so much appreciate your question.
Okay, and thank you. Leah Goodrich, I see your hand raised.
I wanted to emphasize that even if there was a cohesive unit working together, at the end of the day, it still would not be enough if racial justice is not centered. And if racial justice doesn't flow like through that system. So I want to give an example, like with the court system. We're asking, I talked a little bit about interpretation of the laws. Well, there was recently a report last year released about diversity and racial justice just within, and equity just within the court system and the problems facing there. And so I think one question we have to ask ourselves is how can we really expect any system to put forth and to really be about racial justice when within it still is not clear about what that looks like. So we can talk about education, we can talk about working together, but if there's not really a fundamental understanding about what racial justice looks like and it doesn't come from within, meaning that the systems that we're expecting to put this out, they're not doing the work internally just within themselves. They still have sexual harassment claims, racial harassment, racism and discrimination just within their own units, then it's going to be difficult to get the output if it's not internal as well. So I think racial justice needs to be at the center, would be my answer.
Thank you so much. So Don, do you have a question? So Don Durham, do you have a question? If so, can you unmute yourself, please? All right, Don, can you hear us? Do you have a question? Do you need help unmuting? Just hit the unmute button on your web browser.
Don, you should see the, sorry, Brian. I think it looks like Don's looking at it. Don, you should see the option to unmute at the bottom of your computer now. Do you see that? Okay, so Don, feel free to email me your question and I'll get it to Brian. And Brian, if you'd like to go on.
Okay, great. Tiffany? Tiffany, do you have a question?
Yes, I do. Thank you to all the speakers today. My question is both simple and not simple. One of the things that we have heard over the past few briefings is there is not enough data in a number of ways to answer all of our questions fully. And so one of the things that we have been thinking about is, encouraging people who are studying this issue to, in fact, produce more data, especially government actors. But it's also the case that under-enforcement is a problem, and that has been a consistent theme that has come up today. And so my very simple question is why? Why is there so much under-enforcement? Why is there an insufficient amount of data collection that has happened in this specific area of looking at racial discrimination in the context of evictions? I guess I don't understand why enforcement is such a problem. I don't understand why there has been such comparative lack of attention paid to that particular problem.
Okay, thank you. I see Leah's hand is up, if that's up for this question versus. So Leah, you can unmute to answer the question.
I'm sorry, the question is?
Oh, I'm sorry. If you missed it, let me just go on to the other. It could be that your hand was still raised from the last answer you gave. So I'm just going to go on so she doesn't have to rephrase it because it took a little bit of time. But you can listen to the others, and then if you wish to respond, please do so, okay? Because the other panelists wish to. Freiberg?
Thank you. So your question is really great. I wish I had a clear answer because, like I said, I've been involved in this almost 7 years after the Fair Housing Act passed, and I've never seen any type of concerted effort to actually devote the resources needed to enforce the law. Even after the Federal Fair Housing Act was passed, Dr. Robert Weaver, who was Secretary of HUD at that time, asked Congress for adequate monies to hire 900 staff people to implement the new fair housing law. And he only got enough for just under 200 people to implement the law nationwide. And it's been that pattern ever since. The resources have just never been devoted to take this problem seriously. If one of the most intractable problems in American society is race discrimination, why are we devoting so little resources to try and address this issue? And I wish outside of a simple answer of racism and so forth, I don't have a good answer to your question because it has boggled my mind as well as someone who's been deeply immersed in this activity for many decades. So I think your question is great, and I think if some of the government people could answer this question better than I. The first time we saw some state action was really after the Newsday article came out, and all of a sudden, a lot of not just white legislators, but white people in general said, oh my gosh, racism is still a problem on Long Island, and I guess we have to do something about it. Well, I got news. Racism is a problem in the housing market throughout the nation, and we're not doing something about it. And it simply needs to be addressed with a certain seriousness, attention, and with a focus, as Leah said, on racial justice. And it's just not happening.
Okay, so then I'll go to Senator Kavanaugh, Laura Feltz, and then Leah, I'm going to circle back around to you. Okay, Senator Kavanaugh?
Great. I think I'm getting this unmute thing down. So I just wanted, I agree with Fred, and it really, I think on one level, nobody should have been surprised by Newsday, but it really did sort of send ripples through the world that it was so overt and so widespread. And I think we do need to understand that discrimination in all aspects of the market is still prevalent everywhere. It's on the data need, there's a particular problem in that there is not reliable data with respect to evictions. And I think that is, there are probably many reasons for that, but two I can think of is, number one, evictions have become a much, much bigger problem across the board in recent years. I assume you're talking to folks at the Eviction Lab down at Princeton and Matt Desmond, who has won awards for dramatizing the fact that evictions used to be a rare, and they used to be viewed as a terrible and rare thing, and now they are really commonplace. They've become a common tool in rental markets. That is a deeply problematic phenomenon. But the fact that they are done at the local level through numerous local courts that don't have sort of systems for tracking particular activities means that there is not reliable data about where evictions are taking place and what the reasons are, and the racial and ethnic composition of the people that are being affected. That is something that we should consider. I have been considering legislation requiring the Office of Court Administration to more systematically track that, so we'd have baseline data to figure out how different policy solutions might work. But it is a very big problem. I think I'll stop there just because I want to give other folks opportunity.
Yeah, thanks so much. Laura Phelps, and then we'll go back to you, Leah.
Thank you. I would just like to add that I feel that discriminatory practices and racism are so deeply rooted in those enforcement systems, and many of those enforcement systems were actually created to uphold those things rather than try to remedy and reverse them. And so I think we're up against a really massive challenge when you look at something like a summary proceeding that was created so that landowners could evict people very quickly, and to try to flip that and make it so that it could be used to protect a person's rights. And so many tenants don't even have the right, like in New York State, to outside of New York City, to file their own case, to have a separate right of action, to be able to assert some of these rights that we've talked about to fair housing and to housing conditions. And so they have to wait until they're facing eviction in a kind of proceeding that was designed so that the landlord would be able to quickly, efficiently obtain a warrant of eviction that's then enforced by police that often have kind of deep-rooted racism issues in how they function. And the other thing that I would offer with regard to data is that in my personal experience, attempting to obtain eviction data from the Office of Court Administration in my capacity previously as an executive director of a tenants' rights organization nonprofit, it was nearly impossible. We had to retain our law school, we had to retain a university and all of their kind of resources to be able to obtain this data. And we've never actually been able to have a copy of it and house it ourselves to be able to look at it from the perspective of tenants, where at the same time that data was sold to landlords to be able to create blacklists up until 2019. Thank you.
Okay, and Leah, if you can wrap up this question. I know we still have 6 more members, but we have 8 minutes. So, I'm going to try to get to everybody if I can.
Okay, I'll be brief. I just wanted to simply say that this touches a little bit about the topic I mentioned in my presentation about the distinction between empathy and nuisance. So for example, when it comes to people of color, and specifically in the context of Black tenants, there really is not a lot of empathy. We are literally seen as nuisances. And so even in, when I come to speak about racial justice, and I even mentioned slavery, I get rolled eyes. I get people who say, let's move on, let's talk about today. People do not want to do the hard work to look at why we are where we are today, because that would require a lot of empathy, a lot of work that, quite frankly, many people just don't have when it comes to race, and it comes specifically to the history in the US with Black people.
All right, thank you so much. Let me go on to the next member. Bob, do you have a question? Bob Klump? If you can unmute yourself, Bob.
Okay, can you hear me now?
I can, thank you.
Okay, my question is directed to Laura Phelps, and it concerns rent control. One of the remedies that I believe you suggested was universal rent control. And this is a subject that's come up on previous panels. And I've yet to get, in response to this sort of question, any acknowledgement that there are downsides to rent control. And let me just cite San Francisco, okay? The Chicago Policy Review from 2019, while acknowledging that in the short run, rent control helps poor people, poor tenants, in the long run, which is presumably what we're interested in, quoting here, rent control expansion causes a substantial decrease in the supply of rental housing, specifically a 10% increase in the conversion of housing from rental to owner-occupied, typically into condominiums, as well as a 25% decrease in the number of renters living in rent-controlled apartments, and it also leads to a substantial gentrification of communities. And we all know we're all, I think, familiar with the overwhelming problem San Francisco has in that regard. So my question is, how is universal rent control going to remedy or ameliorate the shortage of rental housing? There is study after study, the Brookings Institution, I could cite dozens of studies.
Okay, that question is directed to Laura, so I'm just going to direct it to you if you wish to answer the question.
Sure, thank you. It's a great question. I think it's important to keep in mind that where rent control has really explicit carve-outs, like what we see with the Emergency Tenant Protection Act in New York City, that's recently been expanded. If it allows for sort of incentives or loopholes where landlords can easily evict tenants and convert housing and sort of have like a vacancy bonus, vacancy decontrol, these kinds of things that allow landlords to circumvent what rent control is meant to do, then yes, it's not going to be very effective in the exact ways that you've just outlined. So if you have a strong system that's actually going to allow for true rent control for tenants where they have the right to a lease renewal, where a landlord is not able to simply figure out a way to evict tenants and then move rental housing into those other sorts of unaffordable housing or taking it off the market, and having real mechanisms to be able to enforce the framework of a rent control, which is going to truly protect tenants. All of those things are necessary. And in addition, when you look at some of the other things that I mentioned, such as tax breaks, which allow for luxury developers to have their buildings be subsidized, which is something that we've seen all throughout history, those kinds of things exacerbate those loopholes that you see with rent control. So we have to take a real systems approach when we look at the policy solutions that I've mentioned and that my fellow panelists have mentioned, so that we don't just implement one system with many loopholes. That's not going to be useful in addressing the problem directly. Thank you.
Okay, so we're going to go to the next committee member. What I will ask the panelists, I have to go to public comment at 2:40, and we know that we have one renter that would like to speak to us. So, but if we don't, and it will be a public comment for anybody who wishes to call in, including renters, landlords, and the like. There are times that we've had some extra time left. To the extent you're available to remain on until 3, because I'll have to stop at 2:40 for public comment, we may be able to get back to you with some more questions, but we certainly respect your time. You cannot do so. Vivian, Louie, do you have a question?
I don't have a question, Brianna. I did want to thank all the panelists for their really insightful testimony and written comments. You know, our colleagues have already raised such thoughtful questions. I do want to say one thing that's just internal when we carry this offline. The great question that Tiffany raised about data is something that has come up, you know, that some of us know this already know this from prior briefings on police practices, education that we've done on the committee. It's come up again and again. So it's useful to think about that in our report. Thank you so much.
Okay, great, thank you. So we're still in the question phase. Raphael?
Yeah, so I'll be quick. I mean, all the panelists seem to sort of take as a given the existence of widespread racial discrimination and eviction practices. So the question is, can anyone give us an empirically based estimate of what percentage of New York evictions are directly attributable to racism on the part of the filing party, and how did you arrive at that number?
And who would like to answer that question? Senator Kavanagh?
I will say that to the extent I assume that racial discrimination occurs in the eviction market, I assume that because in almost any other portion of the housing market that is ever studied in America, we find discriminatory practices. It seems highly unlikely that landlords and other participants in the market who are overtly and frequently discriminating in whom they choose to rent to initially are not discriminating at the other end of that relationship when they're choosing whom to evict. But having said that, I think I meant what I said. I'm really anxious to see whether this committee can come up with more formal documentation of the extent of that and you know, the depth of it, and to see you know, what remedies you propose. to the extent you find that it's prevalent. I would also say, though, that given the racial disparity, we know that people are more likely to experience eviction if they are people who are more burdened by housing costs, that they are paying much higher levels of their income on housing than other folks. And we know that though there is good, reliable data, which I could get you, but I'm sure you have access to, that demonstrate that people who are very highly rent burdened that is disproportionately people who are, protected classifications, and that those people are likely to experience higher levels of eviction. But I think it is indirect, and it's systemic. It's systemic racism in the system and systemic biases that I think lead to greater levels of eviction. And eviction is as much a harm, an effect of those. It's both an effect and a cause of very harmful things that happen to people in our society.
All right, thank you. And Leah, very briefly, if you can wrap this up, and we're going to go to public comment, and hopefully I can get back to my colleagues, but let me give you a moment to briefly respond.
So to answer your question, the first thing is when you walk into any New York City housing court and you see who is there, it is overwhelmingly people of color. Now, in terms of empirical data, you can look at the NYU Furman Center. They have shown that, and I'm reading the statistics now, in 2019, it was about 40% of Black tenants, 40% of Hispanic tenants, 6.2% of Asian tenants, and 11% of white tenants in terms of for the eviction filing rates. For 2020, one of the statistics that I named before, and this is from CSS, this is Community Service Society, before the pandemic, Latinx tenants were the most likely to be threatened with eviction at 19%, followed by Black tenants at 14%. And then I mentioned the zip codes before. There has been data that has shown that in majority Black zip codes, the Black tenants there are 3 times more likely to be evicted. So there is empirical data to show that people of color are disproportionately evicted. And also following up with that, when you actually walk into any housing court in New York City, you will see the empirical data envisioned.
Thank you so much. So again, I'm going to ask if the panelists need to leave, please feel free to do so. If you can stay on in the event we have any extra time during public comment, I certainly would come back to you for questions. But I do want to take this opportunity to thank you all so much. I know you put a lot of time and effort into your presentations, extremely informative. We really appreciate your time. There were 3 members who weren't able to ask questions because we've run out of time. We will take any questions from members that weren't able to ask, or if they have additional questions, Mallory and I will assemble them. It has to come through the commission staff, the questions to you, because it has to be a part of the public record. They'll be returned to us, and then we'll distribute them among the committee. But at this moment, I must go on to public comment. But for those of you who can remain, please do so. We are now going to begin the public comment period. This is an opportunity for any remaining members of the public to offer comments to the committee about this topic. I'd ask that you keep your comments limited to 2 to 4, even 5 minutes if need be. As a reminder, all remarks are recorded for the public record, and as chair, I reserve the privilege to cut short any statements that defame, degrade, or do not pertain to the issue at hand. I'm going to now be inviting members of the public to share their comments. First, we'll invite those who have notified our DFO, Mallory Trachtenberg, that they wish to speak. Those will be followed by those raising their hand using the raise hand by selecting your name in WebEx or selecting *3 if joining by phone. I will ask you to raise your hand by hovering your mouse near your name in the participant list, or selecting raise hand from the menu of the 3 dots near the meeting controls. I'm going to first call on Tamika Hall, who has notified us that she would like to speak, and she was scheduled to speak on June 18th when we had to reschedule today. So Tamika, thank you so much for being with us. You may now unmute yourself. We're looking forward to hearing from you.
Good afternoon.
Good
My name is
afternoon.
Tamika Hall. I'm a little nervous. I'm trying to pull up my thing. I don't know where to begin. I'm the nuisance woman that Leah was talking about. I'm that stereotype of person. What was done to me, I hope doesn't happen to anyone else. But I'm gonna briefly tell you my story a little bit. Just trying to pull it up. I'm so sorry. I had it up. I got nervous. I was put out of Greenberg housing a few years ago. I was a mother of, well, I am a mother of 10. I was put out with 9 children. The effects of it are still ongoing, and for us, it'll go on probably for the rest of, I know, my life, and for my kids' life as well. Hopefully, I'm so sorry. I'm really nervous. I just pull it up and briefly I'll say it in less than 10 minutes. I have to say. So just bear with me, everybody. Sorry.
You just take your time, Tamika. We're here to hear you. Your testimony is important to us.
Okay. And I want to say thank you to everybody that helped me at the HUD level. It wasn't easy. I didn't get any help from anyone. And I went through all levels of government, and no one helped me until I got to the HUD level. So I wrote down just briefly what me and my family encountered and what we're still encountering to this day. Because like I said, the effects of it are gonna last lifetime. Maybe my story begins before the actual discrimination and housing eviction began. Like when I started to seek mental health help at Westchester Jewish Community. Talking to my therapist, I realized I was going through verbal abuse, a lot of abuse from my domestic partner. You see, my kid's dad had a disability, drug problem, and an addiction what made him abusive. So I went to the Greenberg Housing Authority asking for help. They have a Section 8 voucher and public housing program, and I was their resident. I asked them to take the kid's dad off the lease out of the house, or even move me and my kids. I just needed help. My ex was disabled, but at the same time, all the bills were being paid through me, and the housing authority just said take him to court. But I was in a domestic situations. The cops have been to my house several times. I was suffering abuse and my kids were seeing it, and the people at the Greenberg housing knew this, and still they did nothing. Maybe this is when the time came, they decided to put me out so fast. I've always been very active in my community, very boisterous. I lived in Greenberg housing practically my whole life. The housing authority staff, they did not like me. I was on a housing council, residence council. So maybe the housing discrimination that happened was because of this. I know a lot of people who, have problems with addiction and they're still there. But me, I was arrested. Okay? But I don't want it to happen to anyone else. I remember the night that I was wrongfully arrested. I was in my bed and so were my kids. I'll never forget the banging on our door. Next thing, the door was kicked in. I had just had a baby. I can't really call. I think I was pregnant. My kids screaming, guns to our head, infrareds. We were embarrassed. The police screaming, yelling at me and my kids. We're never ever gonna forget those red dots. I'm never gonna forget it. They walked me out in the middle of the projects where I lived in the dark in front of everybody. Embarrassed. I'm never gonna live that. I'm always gonna have that stigma. Everybody saw me being pulled out on the lawn. People were wondering why I was arrested because I'm just normally always with my kids or working. Everybody still talks about this arrest to this day. You could pull it up if you put my name in, you could pull it up on the internet. It still hasn't been taken down. Because the the arrest resulted in nothing. All my charges were dropped and sealed. And yeah. To go to the police station, they didn't help me. The whole arrest mugshot, pulled out my pants, writing CPS. I had CPS for a long time because of this. I was shocked when I read the report that said I was a drug addict, because I never used drugs. So some things that are irreversible. I was on a housing resident council, but once they kicked my door in, I was a controversy. I was off of that. My kids' mental health to this day, irreversible. I have 2 sons right now in prison because of where we were stuck. To have 10 people in a homeless shelter live in one room. Number one, as a woman, I can't have feelings. I can't cry. I couldn't do anything. No one knows how that feels. I'm in the mother and I can't do anything. I was kicked out for nothing. I had so many things that I should have been kicked out for. I shouldn't have, excuse me. I had so many things I shouldn't have been kicked out for. I was a domestic violence victim, and I went to them for help, and they didn't help me. My safety was in jeopardy. I went to them, and they didn't help me. What they did was kick me out to, after almost 30 days later, for a judge to tell me I did nothing wrong. They could have waited. I begged the housing authority not to put me out. So I hope this doesn't happen to anyone else. They put me out, and even 2 weeks later in May, like I said, they dropped all my charges. So tell me how this can happen. How am I guilty in one court but not in another? I wrote to offices in White Plains. I wrote to their Office of Civil Rights. I made several complaints against the cop, against the judge. I thought my case was unfair. They started. It just kept going on and on. They started following my kids. They started following my mother. She's scared to death. It's just, we're gonna live with this forever. I was put out of a housing authority really for nothing. But you know, I took it upon myself to look up my rights and see that I could go to HUD. You know, when they took the case, they told me this was gonna be years. And by the grace of God, it was years, but I won. And I just don't want this to happen to anyone else. You know, I really wanted to hear the whole story of what Leah was talking about, because like I said in the beginning, I'm that woman. And we're going to deal with this forever, because being kicked out for nothing, all because of systematic racism. So hopefully, you know, someone hears this, they know someone, maybe is, you know, in a domestic situation, they live in housing and they're not being heard, write to HUD or do something. You know, don't be like me and, you know, have your kids affected for that. Like, we're going to be messed up for a long time, a very long time, because of this. To go from a 5-bedroom into a shelter, 1 room with all of us in it, and then 2 of my kids couldn't go into the shelter, so they had to become homeless at teenagers. It just wasn't right. So I thank you for your time. Like I said, I thank you everyone for listening. And thank you for helping me.
Thank you so much, Tamika, for being here with us today and telling us your story. We're certainly going to be considering that as we write our report with findings and recommendations. I've just been advised by commission staff that we can go until 3:15. I would need 3 members to remain on the line to be able to go to 3:15 to be able to hear testimony. At this point, we're going to continue the public comment. If any members of the public would like to speak to us during this public comment period, please press *3 on your telephone keypad or raise your hand on the web browser. Mallory, do you have anyone who's contacted you that wishes to speak? We do have some members on the public that are, I think, were on participating, but I don't know if they wish to speak.
I have not received any emails separately. And as a reminder, my email address is on the PowerPoint slide. You may email me or raise your hand in the participant list if you'd like to share public comment. And again, you can also submit written comments after this meeting for the next 30 days.
Okay, and Mallory, do you want to check with the interpreters?
Sure. So I don't believe we actually have anybody on either of our interpreter lines right now. Evelyn just checked on that for us, so thank you, Evelyn. And I've just been informed that Fred does need to leave shortly. I don't know who else of the speakers needs to leave at 3, but at this time, I'll turn it back to you, Brian, if you'd like to go back to committee questions, and we can take more public comments until 3:15 if anybody stays on.
Yes, I think we'll go back to the questions because this was a shorter period of time for questions and 3 members were not able to ask them. So Stephen, Raga, and if the panelists can remain, that's terrific. If you need to drop off, and I understand that HUD does it, Tzeitel does, then please do so. Stephen, Raga?
Thanks, Brian. A really quick question, but thanks for all the panelists. Thanks for the other members, and everyone asking follow-up questions. I know we briefly touched on how different government agencies or entities work with each other on how to go about this and support our constituents. But I was interested to know on the legislation end, whether it's on the city and state or even federal, if there's a way or actual formal any procedure in which the legislators kind of prioritize if there's a way to do this on the city level to help folks or the state. I know it's probably ad hoc, but if something like that would help out, especially those under these types of eviction procedures. So I guess my question is really to Senator Kavanaugh or anybody else.
Yes. Senator Kavanaugh? Looks like you're still here. Can you unmute your line if you'd like to answer this question?
Sorry, for some reason there's a delay in the unmute yourself thing popping up on the center screen, but I'm here. Yeah, no, I think there's a lot that can be done legislatively. I think many localities do have the sort of legal authority to make changes in their laws, but I think, I mean, I guess partly because I'm a state legislator, I focus on that more on that. But also, I think it is important that we take responsibility for having for viewing the problem as a systematic problem at the state. The eviction, I mentioned the Housing Stability and Tenant Protection Act of 2019. Took a variety of steps to make it more, make the eviction process more equitable and to some extent just to slow it down. I mean, and to some extent what we were doing in that law with respect to evictions was putting in place formal statutory requirements that had already become the de facto standards in some parts of the state, including in New York City. So for example, it was mentioned before that evictions are a summary proceeding, and they are designed very much to very rapidly turn the property back over to a landlord. And the rapidity of evictions is part of the problem here. So we had testimony that indicated that in some parts of the state, you could go from the day you fail to pay your rent. There's a few days that lagged between that and the point where you could issue a formal demand. And then you would be called into court, and within perhaps a matter of weeks, you could have marshals on your doorstep removing you from your apartment. In New York City, it had become the normal practice that if a tenant comes in and says, I just got these papers, I need 14 days, I need an adjournment so I can get an attorney, so I can get my information together, that would be granted. But not the norm in many parts of the state. And so you had very like head-spinningly rapid evictions. And of course that prevents the tenant from using whatever resources they might have available to prevent it, but it also prevents the government from stepping in effectively with rental assistance programs, so-called one-shot deals that will pay the arrears to prevent somebody from being evicted. So that's a step we've already taken. We should be continuing to review the eviction process to make sure that it is fair and that it allows for the opportunity for intervention given the destructiveness of evictions. The other thing is we should be making sure that rental assistance programs are working effectively, that governments that do have some federal and state resources to prevent eviction are actually using them. And then we had a beginning of a conversation about rent regulation as an intervention here. And I just want to emphasize, I think one of your panelists from Buffalo was talking about lots of evidence that rent regulation has major downsides. I actually think the evidence is mixed at best. And to the extent it's been accusations about New York City in particular, I think much of it is false. I'm not going to go into the details of that right now, but there is a simpler intervention, which is not full-scale rent regulation. And we've mentioned before, it's good cause eviction. And if you think government intervention into this process is excessive, I ask you to consider whether it really has to be in our society that a landlord has an absolute right to put somebody out of their home for no reason. And good cause eviction says the answer to that is no. And landlords, the tenants have a right to continue to live in their apartments, and good cause eviction laws, which stop short of full-scale rent regulation, really would be a huge boon if what you're trying to do is diminish evictions for pernicious reasons like racism, or just more generally for reasons that are not sufficient given the tremendous harm that evictions cause.
Okay, thank you. Nicole, do you have a question? You'd be the next member up for question, and then I'd be going to Craig Trainer.
And I'm not sure if Nicole is still on, Brian. I'm not seeing her in the list.
Yeah, she may have had to leave. Okay, I don't see her as well. Craig, I do see that you're still on. You have a question?
No, Brianne, I don't. Thank you.
Okay, since we have a few panelists remaining, I just want to the extent any of the members have, one or two more questions, I think we could take them to the extent the panelists are available to remain. We do have to go to committee business in about 5 minutes. But if there's anybody else who either didn't ask a question because they took a pass and would like to ask it, or any member who's asked a question that would like to circle back around and ask another one, please just raise your hand in the participant list. Raphael.
Hi, thank you. So in response to my first question, there were a few data points trotted out that seemed to be top-line disparities along racial lines in eviction data. But my question was getting how we can attribute those disparities to discrimination. There's a study that I wanted to bring up, again, from 3 scholars at Harvard, Dean Greenberg, Carl Gershon, and Matt Desmond, called Discrimination in Evictions, Empirical Evidence and Legal Challenges. My understanding is that this is the first study to actually look at and control for all the relevant factors, including those that would legally allow evictions. And that study was not able to find any disproportionate eviction rates along racial lines once relevant factors were controlled for. Are you aware of any study since then that has contradicted that result?
Anybody wish to answer that? And Athena, you'll have the last question because we'll have to go to committee business afterwards. Does anybody wish to answer that question? Leah?
I'm actually a bit confused about the question because the whole purpose of Matthew Desmond's work and actually the eviction lab is showing the racial disproportionality of evictions. So I don't think that your statement
I can
is
read
accurate.
you the quote if you. Sure.
Can
Rather,
we
our
control,
model, this is a direct
but
quote
the
from the study.
overall
Our models show that sorry, if I could just read you the quote, I think that might clarify the question for you. Our models show that African Americans are not evicted at a disproportionate rate after controlling for socioeconomic status, household structure, income, criminal records, and so on. In fact, models that do not control for those factors show that African Americans experience higher rate of evictions than whites. We invite further research on the impact of eviction on African Americans, particularly on those living in primarily non-African American neighborhoods. So again, once he controlled for those factors, the disparity disappeared.
Okay, race and gender disparities among evicted Americans, December 16, 2020, Peter Hepburn, Renee Lewis, Matthew Desmond, quote, filing and eviction rates were on average significantly higher for Black renters than for white renters.
Were there any controls in that study?
I mean, we can take like a quote, but I mean, if what your point is that there's no racial disparity in evictions, then I don't know what the purpose of the advisory council is.
No, that's not the claim is that the disparities would shrink once you control for relevant factors, so that the disparities can't be attributed to discrimination.
I'm sorry, so I'm still not clear about the question.
All right, so what I'm going to suggest doing is, Raphael, perhaps that's a question you'll reduce to writing and we can share it with the five panelists we had today and give them an opportunity to think about it because we only have a few minutes left. I know I said Athena would be the last speaker, but I do see Nicole, who had called on, had wanted to ask a question. So I'm going to ask her question, and I'm just reading from the text that I've received because she did not have an opportunity to ask a question yet. This is from Nicole Rosen, one of our members. Ms. Hall's testimony was a powerful statement of the difficulties tenants face in preventing discriminatory actions and seeking enforcement of existing laws. A number of people spoke to the dysfunction and the lack of coordination between institutions at the local, state, and federal levels, and to the racism that is inherent in many of these systems and institutions. Focusing, as Matt did, on the action that we as a committee are tasked with recommending, what are the specific changes we can recommend that would lead to real change on the fundamental failings? A question for Tzeitel, if she's still on, is what she sees as the HUD level in terms of specific failings at the local and state levels, but that's going to be a question we'll have to email out because this would be too much to answer. Would anybody like to answer that first part of the question? What are the specific changes we can recommend that could lead to real change on the fundamental failings? And we've got about 2 minutes for that. Let's see, some of the, I believe, okay, Senator Kavanaugh.
I'll take a stab at it, though obviously other colleagues should jump in. I mean, I think that, again, part of the thing I was emphasizing is, you know, that conversation we just had about causation is an important one, perhaps, but if you have a series of factors like economic, socioeconomic condition, you know, involvement with the criminal justice system, and you have a long documented history of those things being things that disproportionately affect people based on their race and ethnicity, you know, correcting for those may be correcting out a lot of the discriminatory effect of evictions. If people in our society are experiencing very negative outcomes, and eviction is one of many that is correlated with lots of other outcomes, you know, and it's not only itself a bad outcome, but is exacerbating educational inequalities and all the other things. And I think Matt Desmond and his people have done a good job of demonstrating that. I think there really is a question of whether, as part of our larger commitment to racial and ethnic justice, we ought to be dramatically reducing the rate at which evictions occur in general. And so we've talked about a number of ways that might occur. Good cause eviction is a big part of it. Making sure that we set up systems that view eviction as the worst possible outcome that it usually is. Making sure that housing quality is not so poor that people we have people living in homes that like no decent person should expect human beings in a wealthy society like ours to live in. So all the interventions that we've talked about today, I think, are would address the question of eviction generally, and would particularly diminish the disparate impact of evictions, even if you can't identify the data that shows that overt discrimination is the cause of any particular eviction.
Okay, thank you very much. At this point, I'm going to have to end the questioning. Every member who wished to was able to ask a question. Mikhail had a second question, which we'll forward for all the committee members to hear the answer, which is about what are the failings noted at the local and state levels that HED is able to see. At this time, I want to thank all the panelists so much for your participation. This has been incredibly informative. Your presentations have been excellent. The questions from the committee have been really challenging and tough, and you really shed light on all of these issues for us. To the extent you wish to supplement your testimony here today, we would welcome anything additional in writing, and you have until August 15th. Likewise, we may be sending you additional questions because I know committee members may have some additional ones. So at this time, I thank you so much for joining. If you joined to provide public comment, and Mallory, is there anybody else that wish to give public comment? It doesn't sound like it.
No, there's not.
Okay, so at this time, I thank all the panelists. I thank the committee members. I thank Tamika for speaking to us publicly. We're going to transition from 5 minutes of committee business. You're welcome to remain up if you wish to. So we have 5 members that are still on, so we have a quorum. We need approval of May 21st, June 4th, June 23rd, and June 25th minutes. I'd like to lump them in collectively and see whether I've got a motion for approval of those 4 minutes.
And excuse me, Brian, Jamil sent a quick note to the committee before he hopped off. As a reminder, committee members, you're only able to vote when you're actually present during a public meeting. But for any committee members who are currently on, you may raise what Jamil suggested for discussion for the minutes so they can be approved with the amendments. So anybody who currently has their email up and can see the email from Jamil, I would recommend that you raise that for discussion when she gets to the vote.
Okay, I'm wondering whether we only have 3 more minutes. Can we, I'm not on my email too. Let me just see. Can the approval of the minutes go over to the August meeting?
Let me just read this for everyone, because I think we can cover this pretty quickly. Let me pull it up.
I see. It says, hi, I would vote to approve the minutes, but they should explicitly say that witness or panelists answered questions from committee members. Is that the only recommendation for change? And I am aware that only members who are online can actually take a vote.
That's right. That's all I saw. If any other members have any issues for discussion, please raise your hand in the participant list. Otherwise, if you'd like, you can vote to approve the minutes with the amendment Jamil had suggested.
And are you looking at email to see if there's others? Because running the meeting, I'm not also looking at the emails to see if other members are weighing in on this.
I am looking at my emails. I don't have anything else.
Okay.
Please, so also all members, please use the participant list to raise your hand. We have too many people by video right now to actually see everyone's video. Athena, I think you may have been raising your hand physically. Did you have something that you wanted to say? Okay. I'm sending you a request on mute. Go ahead, Athena.
I was only going to make a motion that the minutes be approved with the addition, with the recommended addition.
Okay, do I have a second? Tiffany, second, so we'll go ahead and take a vote. All in favor? Do we have to do that by the participant list, Mallory?
Yes, please. If everyone can just Yeah,
Okay.
can everyone just give the
Everyone in-
participant list? Thank you.
Yeah, everyone in favor of approving the May 21st, June 4th, June 23rd, and June 25th minutes with the amendment that Jamil stated that I read on the record. Okay, we've certainly got a majority in favor of approving the minutes. Any opposition? You can raise your hand. If there's any opposition. It wasn't already raised. I don't see any, and any abstentions. No. The minutes are hereby approved. That motion passes. Thank you so much. So we can conclude on time. I just want to say that I've been asking for volunteers in the last week to draft different sections of the legislative background. That will include the federal law, state law, Albany law, Buffalo law, and New York City law. At this time, I want to thank Jamil, who's offered to draft the legislative background for federal and federal human rights law, and Bob for agreeing to draft the section on local Buffalo law. I'd ask the rest of you to think about it between now and the next week or two to see if you can volunteer to write either the state, Albany, or New York City law. I expect this is going to be a really comprehensive report, and we'll need a lot of assistance in the drafting, and that's the first portion. But at this time, we can close the meeting. It's 3:16. Thank you so much for the rescheduling, for being able to remain on for an additional 16 minutes. Thank you again to the panelists, the members. This has been a terrific briefing, and we'll look forward to starting our debriefing on August 20th from 1 to 2:15. Thank you.